back again to Business 80, and today I'm going to be giving you some very good nuts and bolts information about something that you also have to really know. And this particularly is true if you decide to start your own company or go work for a startup that needs your ingenuity. And the one thing that I want to make very clear, and you will be tested on the final on this concept, and I want you to write this down, is that you cannot legally protect an idea. You cannot legally protect an idea. It amazes me how often I could be in a Starbucks or a Peet's Coffee, and now Phil's Coffee is becoming pretty popular. People bragging about their ingenious ideas and how they're going to go to market with their concept, and they're going to be a huge disruptor in some niche area. Could be in high tech, could be in any segment of the business world. But it's just amazing to me how ignorant people are. Because if there's a business analyst sitting in the room and it's one of their potential competitors, you hear everything that people are talking about, and it's nothing to rip off somebody's idea. Now, I'm not suggesting that that's good practice, but I can tell you that our courts are crowded with copyright cases and copyright infringement cases and trademark violations, etc. So, if I declare to you as a clear statement of the law that you can't protect an idea, well, what can you protect? How do you create a copyright? How do you create a copyright? By simply creating something in tangible form. Now remember, I gave you the definition of a good, which is a tangible or a movable at the time of identification of the contract. So too is this concept of copyright attaching to something tangible. And I'll give you some examples. I'm an oil painter. I love to paint. I've been influenced by people like Chagall, and Van Gogh. I kind of combine the two of them. Chagall and Van Gogh. I love their art. My style is reminiscent of some of the colors of Chagall and some of the brush strokes of Van Gogh. As soon as I create a painting, I own the copyright. By simply painting that painting is my creation, and it belongs to me. Any filmmaking students in the class? All right. So as soon as you make a film, or heck, even create a photograph, you own the copyright. If you've written a script, a film script, or written an article, and you are the true creator of that, not a republisher, but if you are the creator of that piece of work, then you own the copyright. You own it. It belongs to you. But you might suggest, well, Mr. Silberman, that's interesting how I can automatically create this copyright if it's affixed in some tangible form. But the next question has to be, how do I protect my copyright? In other words, how do I let the rest of the world know that I'm declaring this piece of content as my own? And it's very simple. Almost as simple as creating the copyright from the get-go. And you've seen this. Everybody's seen it. Everybody in this room has seen the copyright symbol, which is simply a C and a circle and a year and your name. That copyright symbol rests on some piece of your artwork. If it's a painting, it should be somewhere on the painting or the back of the painting. If it's a script, if it's a Hollywood script, then you're going to put your name and the copyright symbol. If it's an article that you've written or a blog post, then you put the copyright symbol, the year, and your name. Now, what if you want to protect a script, a movie script? There are a couple extra things you can do. One is you can submit a copy of your script to the Writers Guild of America. There are two offices, one on the West Coast in Los Angeles and one on the East Coast in New York. So depending where you live, you're going to want to submit that script either to the WGA office in Los Angeles, I think it's Beverly Hills, I'm not positive, or the one in New York if you live closer to New York. The other thing you can do to protect your artwork is to use a particular form. The Library of Congress and the U.S. Patent and Trademark Office will supply you with the relevant form. If we're talking again about a script, then you're going to use a PA form. Anybody know what PA stands for? Performing arts. So if you've written a script or a play or a song, maybe you've got the next hip-hop single that's going to make the whole world shake. They're going to love it. You're going to sell billions of copies, I hope, and it goes platinum. Then you'll want to submit a PA form along with a copy of your song. Could be a recorded copy. Could be the lyrics. If you've written lyrics to a song, on the lyric sheet, you're going to put your name and this copyright symbol. That proves to the rest of the world that you're trying to do what? Protect your copyright. It's amazing to me how many times I've given a lecture on intellectual property, and if I ask the group or the crowd, and regardless where I go, I ask the group, how do you create a copyright? And everybody says you put the little C with a circle. That's how you protect the copyright. Does everybody understand the difference? You can create your copyright with never protecting it. It's a little bit dangerous, but if you go to court and you can prove that you were the first party to create that artwork, you may still prevail in a copyright infringement case. So what can you copyright? Things, not ideas. You cannot protect an idea. If you have a great idea for a script or a book or a song, write it down in a tangible form. Put the C in the circle with the year and your name. And if you want the extra layer of protection for international copyright protection, and there's a caveat to that, then you go to the Library of Congress or the U.S. Trademark and Patent Office. There are certain countries that do not respect our copyright laws. There are many countries that do. In Switzerland, I'm going to say about 50 years ago, there was something called the Bern Convention. That convention was held in a city called Bern. I think it's B-E-R-N-E. I'm not positive. And many countries that wanted to respect each other's copyright laws signed an agreement saying they won't rip off other people's copyrights. Now, there's some countries that don't believe in the Bern Convention. And you're at risk if you're delivering content internationally. Heck, you're at risk if you put something up on YouTube, because that's for the entire world to see. Anybody can see it, right? Once you've produced that content and published it on YouTube, anybody in the world could see it and use it. And if you don't have the copyright symbol somewhere on there, then anybody can misappropriate it for their own use and make money off it. So, how do you avoid litigation with a company in another country where that country does not respect the United States copyright laws or is not a signatory to the Bern Convention? How do you protect yourself if you're selling a piece of content to a company that is resident in another country? How do you attempt to protect yourself? Through contract. Is that what you're going to say, Michael? Okay, good. Through contract law. You say that if there's a dispute as to the ownership of the content, that dispute shall be submitted probably to the United States District Court or Federal District Court near where you're doing business, so it's convenient for you. You would also want a clause that if there's any litigation about who owns the copyright, that you will either use the laws of the Berne Convention, the signatory agreement, or U.S. copyright law. Otherwise, you can be ripped off like crazy, and they can say, oh, well, we don't recognize United States copyright law, or we're not a signatory to the Berne Convention, so tough luck. You should have protected yourself in the contract. Any questions about copyright so far? Yes, Edgar.
Simple question. What was the office that you said that you can send it to Los Angeles?
So there's a library. Oh, if you're writing a script, that's only for a script, like a movie script, maybe a play, you would go to the Writers Guild of America, WGA, and I think there's an office in Beverly Hills on the West Coast, and then in New York City for the East Coast. WGA, Writers Guild of America. It used to be a $25 charge. I'm not sure, it may have gone up. Now, what if you made a film? Can you have a copyright? Can you own the copyright to a film? As soon as you finish it, right? As soon as it's done, you own the copyright because it's tangible. You can pick it up and look at it. You can pick up the DVD and it's now affixed in some tangible form. All right, so that's copyright. What's a trademark? If a copyright protects a tangible item, which expresses your ideas and creativity, what is a trademark? All right, a trademark is simply a name of a product that you want to protect. Could be Coca-Cola, could be McDonald's, could be Nike, FUBU, any one of those products. You want to trademark those names so someone doesn't steal the name of your product. There was a litigation case about 30 years ago, and there was a company, it was a hamburger restaurant, and I think their name was McDougal's or something like that. And the court, what the court will do in terms of scrutinizing whether or not there's a trademark infringement is simply ask a question. And the question is, to what extent could consumers be confused as to the identity of the correct trademark holder? So if you're pulling up to a McDougal's and it looks just like a McDonald's, then you may in fact be proof positive that McDougal's has infringed upon McDonald's trademark. You probably see a lot more copyright infringement cases than you do see trademark infringement cases. Most savvy business people, and this ties into last week's talk about how to legally form your company, most companies, before they try to protect their company, will make sure that their name is available by doing a business name search at the Secretary of State website. We talked about that last week. It's a free search. So you can see if somebody has a similar name. Now, you can't protect very obvious names. If you wanted to start a university and you wanted to call it University, you can't really protect that because it's too obvious. And there are some names that you can't protect either, like the Smith Company. I mean, that's just such a common name that you may not be able to have the legal rights to protect that name. If you send it in the trademark office, they can reject your application because it's too obvious. If you want to have a rental car company and you call it Car Company, it's too obvious, you won't be able to protect it. So again, we have a lot more copyright infringement cases. You remember the case between Microsoft and IBM, I believe it was, and they were arguing about some proprietary software that was getting loaded onto Macintosh or one of those devices, and there was a question about who owned the copyright. I think it was Microsoft and
Was it
Apple. Yeah. So you see a lot more copyright infringement cases, but if you have a startup and you want to protect your idea, please keep your mouth shut until you have it protected, until you put that copyright symbol on there. Otherwise, it's fair game. Anybody can steal your idea. And it happens all the time. Chances are, once your idea is out there in the ether, somebody else can pick up on it. Yes?
What was the difference between a patent and copyright?
So we haven't talked about patent yet. You can obtain a patent if you have devised a new way of doing something. It's remarkably difficult to obtain a patent. Usually you see this on products. You may see it on the new battery for the Tesla. This may be a new way of making batteries for an electric car. Often, if you get a new device and it says patent pending on it, you've seen that before, that means somebody has applied for a patent, but it has not yet been granted. Now, typically, to apply for a copyright protection, you can do it yourself. Trademark, same thing. Patent, I really think if you have some sophisticated design patent, you really want to go to a patent lawyer. Most patent lawyers, before they became a member of the patent bar, were usually engineers. Now, it's interesting that you can become a patent attorney without even going to law school. If you are an engineer or you have some type of engineering background, you can take the patent bar, and if you pass it, you can practice patent law. And of course, here in the Valley, we probably have more patent lawyers than anywhere in the world. So if you have a great idea for a new way of doing something, a new procedure, or a new way of creating a product, it has to be different, it has to be new, then you can apply for a patent. Now there's one more thing I want to talk about, and that's a service mark. A service mark is like a trademark, but it's for a service-related business. So if I have a glass of soda or a cup of soda and it has the Coca-Cola logo on it, or Diet Coke in my case, that name has been protected under a trademark. It's a product, right? You can pick it up. It's a movable. But a business name for a service can also be protected under a service mark. One example would be Roto-Rooter, and this is a plumbing company. So they have been able to protect the name Roto-Rooter by going through Washington, D.C. and requesting a service mark protection for Roto-Rooter, for a service, right? Now, if I want to come up with a new chicken restaurant, and I want to call it Pollo Muy Loco, would I be sued by Pollo Loco for trademark infringement? Probably. The question becomes, to what extent is the public confused? Are they going to Pollo Loco? Or are they going to Pollo Muy Loco? Is it the same place? Is it a different place? I don't know. Just one example. So when you're trying to determine if there is a trademark infringement, the question you will need to ask on your final, or answer rather, is to what extent could the public be confused? If the public is confused between Pollo Loco and Pollo Muy Loco, then you might have a trademark infringement case. And then, of course, I gave you the example of McDonald's versus McDougal's. Obviously very close, and the public can be confused. One more thing I want to talk about is something called invasion of privacy. Now, under the United States Constitution, and harking back briefly to our lecture on constitutional law, you may remember that I told you there is no such thing as protection of privacy under the Constitution. Some justices have argued that under the penumbra of rights, the right to privacy can be implied or suggested, but nothing in the Constitution and nothing in the amendments grant us an unfettered right to privacy. Doesn't exist. There may be an expectation of privacy, and we talked about a new line of cases, particularly up in Humboldt County in California, where helicopters were flying by and arresting people for having significant harvesting of marijuana. And those people were arguing, hey, wait a minute, you violated our privacy because you flew by, you had to come in from a helicopter view to see my property, and the moment you flew over my property, you were violating my expectation of privacy. The court said no. There is no expectation of privacy from a bird's eye view. Anybody could see that. Now, if you would have covered it up somehow, maybe you could have argued that, but those plaintiffs lost the cases. There is no expectation of privacy from a helicopter or an airplane view. Question?
So what about the view from like Google Maps? Is that the same as the bird's eye view?
Google Maps. So the question becomes, is there an expectation of privacy with respect to Google Maps?
Well, is that the same as like the helicopter bird's eye view?
Well, it depends what they're using it for. Now, if the police department or the sheriff's department have some alliance with Google, and they're using that technology to try to arrest people for harvesting marijuana, then you can make the argument. But just by virtue of Google having the ability to see over your property, there may be cases that are pending where people are claiming an expectation of privacy violation, but then what are the damages? Here the damages are clear because people got arrested. Good question though. Moving forward in time, there could be some litigation that comes about as a result of the Google Maps. I hope not, but it's possible. Not that I have stock in Google, but. All right, so under this concept of right to privacy is a subdivision which is called misappropriation of one's likeness. Let's say that Edgar is a famous actor in Hollywood. And I have a chewing gum company, and I use a photograph of Edgar on a billboard holding up my chewing gum. Now, historically, it seems that celebrity endorsements help companies sell more product, right? If you give the opportunity to LeBron James to wear your tennis shoes, probably your sales are going to skyrocket because he's endorsing your tennis shoes or your basketball shoes. So if I'm using Edgar's face to sell my chewing gum, without Edgar's permission, he will sue me under a violation of his right to privacy, and more specifically, he's going to sue me for misappropriation of his likeness. I'm not using him, right? I'm not using Edgar, but I'm using a photograph of Edgar or his likeness. Or if I use Justin Bieber's voice to promote my new clothing line, and I don't have Justin Bieber's permission, he's going to sue me. Right?
If you're putting pictures online, though, can't you use those pictures because they're open to the public?
The question is, can you post pictures online? If you are deriving financial gain from that, then you could be sued. If you're simply reposting something with no financial gain, chances are you don't have anything to worry about. However, there's still a possibility if you don't have a release from somebody, right? And it's more specifically problematic for lay people. So if I were doing a movie and I wanted to shoot the entire class, I wanted to show the entire class, I better get a release, a talent release from each and every one of you if I'm going to show the movie in a theater. Because you could sue me and say that I invaded your privacy and I misappropriated your likeness without compensation. But typically, you know, photographs of the president are really well-known celebrities. If you're not making money from it, probably not a problem. Now, if you are putting that person in an unfavorable light, then you could be sued. You know, there are a lot of sites that put celebrities' faces on other people's bodies. And if they don't like the way they're being depicted, then you could get sued. Questions?
I have a quick question. So I know, using the big picture and everything, and a lot of people, like, in YouTube, like to, comment on the company's, presentation or their product. Can you get through that if you don't share for it, and then, do a review of it on YouTube? You know, maybe not YouTube, but kind of keep them back from your
Right. So the question becomes, if you give a bad review for a company on Yelp or YouTube or anything like that, can you be sued? Now, one would think that we just look to the First Amendment for our answer, right? Because we have a freedom of speech, don't we? But if you have malicious intent to bash your competitor, you might be sued. As a matter of fact, there are people that go around maligning their competitors on Yelp to get an unfair advantage. Lawsuits have been brought. People will make up phony reviews of places they've never even been to try to sabotage their competitors. But if you're just a lay person reviewing a new television, chance of getting sued are really, really low.
Because I hear about, I don't know, I watch all YouTube, sick thing, and then they're just like, oh, I took my video without it because the company, contacted me saying they're
It'd be very difficult to sue for giving your opinion. Unless you were the competitor, you're doing it maliciously to hurt them. Yeah. Otherwise, nobody would ever do any reviews of anything. You get sued for doing a review of a movie if you said you didn't like the movie.
How would you prove that someone is actually trying to just maliciously, harm your company rather than it's actually a person who didn't like the product? Like, how would companies go about proving that?
Okay, so it would go to court. Now, I've had discussions with business owners where they received unfavorable results or reviews on Yelp. And after looking at the review and the person's name or initials, they determined that that person was never even a client. Right? So then they file a lawsuit. Now remember, anybody can file a lawsuit for anything, right? We don't have to prove our case when we file our lawsuit. Through the discovery process, through asking questions, now sir, when was the last time you were at my business? Oh, I've never been to your business. Then how'd you write a review? Why did you say that you were at my business? So through asking questions, you start to discover whether or not there's a claim. Yes?
I know somebody just came out recently, like what you were saying right now. I know there was I guess it came out just recently in the news how someone wrote a really bad review of Yelp about I think it was a restaurant, and they say now they have terrible customer service and everything, and then they do the dates, and they're just the person just walked in or walked out, you can't really see what happened, maybe if you weren't really concerned, and then they don't review down because of that.
Yeah, so Yelp will take reviews down. That's part of their service. And that sounds like a bogus review, right?
Yeah.
But if you are a bona fide customer and you go into Albert's tea shop and you had a great experience, Albert's tea service, and they don't like it, and they write an honest review, you can't sue them for that. That's their opinion. You remember, when you're suing somebody for defamation, if you're giving an opinion, you can't sue. It's only a publication of an untrue statement that injures plaintiff's reputation. So you can't sue for defamation based on someone's opinion. Lies, yes. You can sue for somebody lying, but you can't sue somebody for their opinion. Otherwise, nobody would be ever allowed to give an opinion.
Just looking for my PowerPoint. Sorry.
I'm looking for my PowerPoint too. All right. Any questions about copyright, trademark, invasion of privacy, misappropriation of likeness? Everybody feels pretty solid about that? It's important stuff, right? It's important for this class. It's also important for real life. Because if you create the next great idea, you better have it protected. Does that make sense? Everybody understand that? Okay, so last week when we were talking about business formations, we're talking about protecting your personal assets. Now we're talking about protecting your ideas. And that could be just as important if you have a great idea. That could inure to amazing assets if you have a brilliant idea. And I bet there's some brilliant ideas in this room right now. Please protect them legally. I don't want to see you getting ripped off by someone else. All right, now we're going to go to the next mini lecture, and we're going to talk about landlord-tenant law. Why would we be talking about landlord-tenant law in a business law class?
Most companies rent land and not.
Absolutely. Most companies are going to rent space. Or you might even be in charge of acquiring leases for your company. A lot of growing companies have leasing departments. Their job is to negotiate contracts for leasing space, particularly if you're a growing company. I don't know how many buildings that Google has. I know they have some in Mountain View, probably some in Sunnyvale. I'm not sure. But however they secured that space, they had to have a legal team and people that knew a lot about landlord-tenant law. Now, the laws, granted, are a little bit different on the commercial side than on the consumer side, but there's some similar concepts. And that's what I'm going to talk about today. Now, remember, in California, if you have a lease for real property, that must be in writing to be enforceable. Now, can you live or rent a piece of property without a lease? Yes. It's probably going to be treated like a 30-day agreement. That means if you have no lease, it's on a handshake, then the landlord, whether it's a commercial space or a consumer space, all they have to do is give you 30 days notice and you have to vacate, which can be scary if you're building up your business, particularly if it's location relevant. So if you have a retail spot like Albert's Tea House and you want a great location, having that lease tied down may be important. If you have an e-commerce business, probably not as important. You could be working out of your house. So what is the difference between a 3-day notice and a 30-day notice? Typically, a landlord can give somebody a 3-day notice for any reason. Maybe the person breached the agreement. And I'll give you an example in a moment. It could be something as simple as having a pet at your retail location when you're not supposed to. It could be engaging in a business that wasn't agreed to in the initial lease. Could be making lots of noise. So they give you a 3-day notice and they say you've got 3 days under this notice to correct the problem or you have to leave. Now, usually a 30-day notice is used when the tenant has not paid rent. Not always, but typically. So under a 30-day notice, the tenant has the right to cure the deficiency or quit the premise. Quit the premises. They have the ability to cure the deficiency or quit the premises, which means leave. Now, if I have a year lease with Monica at my optical lab, and she gives me a 30-day notice because I didn't pay the rent for May, and I leave, and I'm on a year lease, I'm supposed to be here till next June, but I didn't pay for May, can she still sue me for the deficiency of that contract? Yes. The answer is yes. So even if I had a 3-year contract with Monica, and I didn't pay this month's rent, I've been paying my rent on time, but for some reason May comes around, and I have some financial issues, so I can't pay the rent. She can serve me with a 30-day notice, and if I don't pay, I leave. But that doesn't mean she can't still sue me for the balance of that contract that I entered into. She gets the premises back. She now has the right to possess or repossess the property or the unit, but she hasn't given up her rights to sue me. Does everybody understand that? That's very important. It's very important because if you start a business out of school and you lease an office space for 5 years, first of all, I would say that's too long. Try 1 year with the option to extend it, because you don't know if your business is going to be successful or not. You don't want to be stuck in a lease agreement for 3 or 5 years if your business is going to tank. Well, you might say, well, I'll just leave and not pay the rent. Yeah, but then they'll sue you and you'll get a judgment against you and your business for the next 10 years. And if you didn't properly legalize your business through an LLC, an S Corp, or a C Corp, then you can get a personal judgment and then go after your personal assets. So now Monica might sue me personally and ruin my credit rating because I didn't pay my rent. Now I must tell you, typically speaking, in California, most tenants under residential leases have a lot of protection. Through manipulating the system, they may be able to stay in that apartment for many months, even after they have been served with a 30-day notice. The first thing they can do is to file an answer. They can just go down to court and file a response to the complaint. And that could extend their ability to stay in the apartment for another 60 to 90 days before there's even a hearing. And if there is some deficiency in the complaint, or if it wasn't served properly, then you can tack on more time. I have seen situations where people have been allowed to live in their apartments for a year after they've been served with a 30-day notice. Now, because of a housing shortage currently, particularly here in the Bay Area, judges are being pretty lenient with people, and they're saying, hey, if you can pay the rent, if you can come up to speed, how much longer will you need before you can find another spot? And, well, it's really hard to find a place in the Bay Area, so they might tell the judge, I need another year. Well, now they're paying rent, but they haven't been kicked out. They haven't been evicted. So there's a lot more protection for consumers under residential lease agreements than businesses. You don't pay your rent in a business, you're probably going to get kicked right out of there. Now, I told you I was going to tell you a story, and I'll tell you that. I knew a lady, actually a client of mine many, many years ago, and she had a tenant who moved in to her strip center. It was like a business office center, little small businesses, and they were peddling drugs out of the unit. Not only that, but they decided to live in the unit. This is a commercial space. And they had dogs in there. It took like 6 months to get rid of that person. And then they tried to file a lawsuit for the deficiency. It was a 3-year lease agreement, but the person was such a flake they could never find him. So be very careful who you rent to. if you own space, make sure that you do a good credit check and you get some references, because if you're stuck with a bad tenant, it can ruin your life, financially and spiritually and every other way. There's a movie with Michael Keaton, and it takes place in Pacific Heights in San Francisco. I think it's called Pacific Heights. And he's like the tenant from hell. You should see it. It's an interesting movie if you want a practical analysis of what could happen when a residential lease goes very, very bad. Great movie with Michael Keaton. All right, any questions about landlord-tenant law? Yes?
Can you not give a you said you can give a 3 days notice for any reason, so can you not give a 3-day notice for not paying?
Could you not? Could you just go, yeah, you can just serve a 30-day notice for non-payment of rent, absolutely. You don't have to give a 3-day notice. You don't have to. You can go right to the 30-day notice.
Well, I mean, if you want the person to leave, a 3-day notice is...
No, well, it depends on the contract, but typically the shortest period is 30 days. And if you don't have a lease, it's treated as a 30-day notice. 30-day tenancy, I'm sorry. Yeah, so you have to give 30-day notice.
If say the house is like inadequate or whatever, like it's not up to standard, then can you withhold rent?
Okay, great question. If the premises is not habitable, and one example could be the toilet's not working, or the sink isn't working, the basic plumbing isn't working, or it's infested with bugs, right? Bed bugs, whatever. Could be all kinds of different problems. In California, I can answer it in California, then you have to contact the landlord and ask them to cure the problem in writing. If a reasonable period of time goes by and they don't fix it, there's something called repair and deduct. So as the tenant, you can dig into your pocket and fix the problem and deduct it from your rent upon the showing of a reasonable receipt. Does that answer your question? Any other question? All right, we are going to be doing a group assignment today, and I'm hoping that everybody will show up after the break. Turn off the camera. One other thing that I want to end on, and this relates back to the first part of the lecture on copyright law, is something called licensing. This is very important. Licensing means that one party has the right to obtain profits from the distribution of content, but doesn't own the copyright. How does that happen? It's called a licensing agreement. Example, I have a contract with Walt Disney Company to sell t-shirts with Donald Duck on it. Will Walt Disney ever sell me the copyright to that? Absolutely not. They will probably make billions of dollars on that character into the future. However, if they feel that I can adequately distribute these t-shirts in a quality presentation, I will enter into a licensing contract with them whereby I have the right to use their copyright, but I don't own it. I will never own it. At some period of time, after some period of time, my licensing contract will conclude. It could be renewed, but if for some reason Walt Disney doesn't like the way I'm selling their product, or now they say, hey, you used to use 100% cotton on your t-shirts, now you're using synthetic quality, and we don't want our product to be represented in such a horrible and despicable fashion, they can cancel that licensing contract or that licensing agreement. People have made millions, if not billions of dollars through licensing agreements without ever owning the copyright. Does everybody understand that concept? All right. So our problem that I want you to talk about actually deals with a licensing situation. In this particular fact pattern, we have two artists. They could be silk screening artists, I'm not sure. And they both claim that they have the right to make and sell posters of the famous Mona Lisa painting that was created by Leonardo da Vinci. And it hangs in the Louvre Museum. They only let a few people in at a time to see it, but it's claimed that if you look at Mona Lisa's eyes and you can follow her eyes, then they will actually follow you through some amazing wizardry of Da Vinci, the artist. Now, in this particular situation, I'm asking you, as between these two artists, who has the right to this licensing of the Mona Lisa poster? And having said that, we will now take a break, and we will come back at 4:30, and we will discuss this problem. I'm giving you very, very bare facts. Again, the facts are, two artists, Sven and Julie, claim ownership of the rights to make posters of the Mona Lisa. Who wins?
Is there any difference between Sven and Julie? Is there any difference between the two people?
There's two artists that claim they have the right to use the Mona Lisa poster. One might be more intelligent than the other. Or a better liar, yes.